Now I would like to invite Gautam. Komal, thank you very much for giving insights onto how we can manage the crisis. Now I would like to invite Gautam to tell us in case we are not able to handle the crisis and organizations are actually getting into insolvency or bankruptcy. What is IBC is all about, and is there any fate of the organization of revival using IBC in future?
Thank you, Abhinav. Good afternoon, everyone. So, first of all, we must understand the meaning of the terms insolvency and bankruptcy. We often use these terms, but insolvency is a state of being unable to pay the money owed by a person or company on time to its creditors. So, when there is stress in any business or in personal life of any individual, where he is not able to pay his debts on time, or where a situation
Gautamji,
comes.
can you please little bit loud?
Yes. So is it fine now?
Yeah,
Yes.
better.
So insolvency is a state where an organization or an individual is not able to pay its debts on time. So that means he's under stress. The liabilities are more than his earnings or his assets. Whereas bankruptcy is a legal status of a person or other entity that cannot repay debts to creditors. So insolvency is only a state where a person or an organization comes under stress. But bankruptcy is a legal status whereby so what should be done? Once a company or an organization comes under stress, the question arises, what needs to be done? So should we leave that person or that organization alone to die its own natural death? Or should we try to resolve that insolvency? It's simply equivalent to a person getting sick. But in India, what we usually do, a person who is under stress, especially under financial stress, we start equating him with a fraudster. So that is the biggest problem in India. We need to identify where a person or a business is under genuine stress and try to resolve his insolvency rather than pushing him into liquidation or bankruptcy. And with this precise objective, Insolvency and Bankruptcy Code was enacted by the Parliament in the year 2016. Now, the main purpose of insolvency and bankruptcy laws are as under follows. The main purpose of insolvency law is to resolve, as opposed to liquidation or closure of the business of the debtor. The basic purpose is an organization not only uses its own resources, but lot of resources are put in by the government as well as other stakeholders, especially employees. The employees are totally dependent on the organization in which they have been working for so long. Any organization may come under stress, and it is easier to close down the organization than to keep it as a going concern. However, if an organization is kept as a going concern, it will ensure maximum debt repayment to its creditors as opposed to liquidation. It will improve in reducing of conflicts between debtors and creditors. It will provide creditors better way to get back their money. It will provide a chance to the insolvent entity to repay its debts, and debtors' economic rehabilitation will take place. And it will set a limit between malfeasance and business failure. Now, this is the biggest problem, especially in India, where the banks, under the existing laws, have no choice but to differentiate between a genuine business failure or a malfeasance or a fraudulent act. The laws are, it reduces burden on judiciary. So there are various laws existing in India, even prior to enactment of IBC, dealing with insolvency of individuals as well as companies. These are some of the main acts which are in operation even as of today. Some of them have been repealed, others are still in operation. The Presidency Towns Insolvency Act 1909, the Provincial Insolvency Act 1920, the Companies Act 1956. It had various provisions relating to winding up of the companies where the companies are not able to repay their debts. The Sikh Industries Companies Act 1985, the Recovery of Debts and Bankruptcy Act 1993, Securitization Act of 2002, Limited Liability Partnership Act, and the Companies Act of 2013. All these acts have different provisions relating to different entities dealing with insolvency laws. So what IBC did in 2016 was to consolidate the laws, all the laws scattered in various statutes under one umbrella. So that's why it was called Insolvency and Bankruptcy Code rather than being called as an act, because it is an umbrella whereby all the insolvency laws relating to different entities and organizations and individuals have been put under one umbrella. Now the preamble is very clear and gives as to why this act has been incorporated by Parliament. It says an act to consolidate. So the first objective was to consolidate the insolvency and bankruptcy laws, which was scattered under various different statutes for so long, and amend the laws relating to reorganize the businesses and insolvency resolution of corporate persons. By corporate persons, we mean companies, limited liability partnerships, partnership firms, and individuals. So this code takes care of all types of businesses, as be it a corporate person, a partnership, or an individual. And the second objective is this insolvency resolution should take place in a time-bound manner. And the purpose is for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interest of all stakeholders, including alteration in order of priority of payment of government dues. Now, under Companies Act and other insolvency laws, the government dues always had a priority of repayment. The government always had priority as opposed to other creditors. However, under Insolvency and Bankruptcy Code, it is for the very first time that the government dues have been kept at the bottom of the waterfall mechanism. Now the government dues don't get any priority in repayment. So this is one of the reasons why the government has shown its intention that they even the government wants to resolve insolvency of organizations, and in that process the government is ready to forego its taxes and dues, and to establish an Insolvency and Bankruptcy Board of India. Now, this is the regulator which regulates the entire insolvency mechanism in India as of today, and for matters connected therein or incidental thereto. Now, the debt recovery mechanism as it existed in India prior to 2016 is known as debtors in possession. Now, by the word debtors in possession, we understand that once there is a default by any organization or individual, and a recovery suit or case is filed by the creditor, the debtor remains in control of the assets of the company till the time an adjudicatory order is passed by the court or tribunal. As a result of which, the organizations which are under stress, they are fighting the cases with the creditors using the money of the creditors themselves. They remain in control of the businesses, the litigations drag on, and the defaulting entity, they siphon off the money, even if it was not initially a fraudulent act which led to insolvency. But during the course of proceedings, since the debtors used to be in control of the organization and the funding, so they always used to siphon off the money during the proceedings, recovery proceedings under various statutes. Now, under IBC, the entire recovery mechanism, I will not call it a recovery mechanism, but the entire resolution mechanism has been shifted to a regime known as creditors in control. The movement and application under Section 7, 9 or 10 of Insolvency Act, which we will see later on in subsequent slides, is admitted by the adjudicating authority, which is National Company Law Tribunal. The powers of board of directors of the company get immediately suspended, and an insolvency professional takes control over the assets of the company, not only the assets but all the affairs of the company, and he forms a committee of creditors, which is sort of a board of directors which consists of various financial creditors of the company, which guide and control the insolvency professional in his endeavor to resolve the insolvency of the corporate person. So this is a very big difference which was brought in by the government by this 2016 code. Creditor in control means that the lenders, creditors immediately comes in control of the business assets of the borrower upon admission of the petition under IBC 2016 through IRP or RP. So the basic objective of this is that once the company is under stress, the directors, the management, once the company is under stress, the directors and the management, they get desperate to repay the debts because there is pressure from the lenders to repay. In that desperation, they start taking loans at higher rate of interest. They start putting in their personal assets in the business without any exit, without any actual resolving insolvency. It only aggravates the situation. So Insolvency and Bankruptcy Code was enacted with all these objectives in mind, and there are 5 parts of Insolvency and Bankruptcy Code. Part 1 is preliminary. Part 2 deals with insolvency and liquidation of corporate persons. Corporate persons include companies, limited liability partnerships. Part 3 deals with insolvency and bankruptcy for individuals and partnership firms. As far as Part 3 is concerned, as of today, only entire Part 3 has not been implemented, notified as of today. It is only with respect to the guarantors to corporate persons that Part 3 has been notified. Is a guarantor to a corporate person which is under stress. In that event, insolvency of an individual or a partnership firm can start. If they are not the guarantors, insolvency of individuals and partnership firms could not start. Part 4 deals with regulation of insolvency professionals, agencies and information utilities. And Part 5 is miscellaneous provisions. So today, we will be focusing basically on insolvency resolution and of corporate persons. So there are few basic terms which we must understand before we move forward to understand what Insolvency and Bankruptcy Code is and how it is implemented. Section 3.8 defines a corporate person. Corporate person means a corporate person who owes a debt to any person. Partnership, a Section 8 company. All these corporates who owe debt to any third person is a corporate debtor. So there has to be a liability. Now, creditors under IBC are classified under 2 heads. The classification is a financial creditor and an operational creditor. A financial creditor is a person to whom financial debt is owed. And a financial debt means a debt along with interest, which is dispersed against consideration for the time value of money and includes money borrowed against the payment of interest. So wherever a company borrows money against payment of interest, it will be known as financial debt, and the borrowing and the creditor will be known as financial creditor. Whereas an operational creditor is a person to whom an operational debt is owed. And operational debt means a claim in respect of provision of goods and services, including employment, or a debt in respect of payment of dues arising under a law for the time being in force and payable to the central government, state government, or a local authority. So if we look at the definition, the government dues have been equated with the dues of other operational creditors like employees, like suppliers, service providers. Whereas debts given owed to banks, NBFCs, or where money is borrowed are classified as financial debts. This definition and classification is very important because when the committee of creditors, which I talked about earlier, will be formed, it will consist of financial creditors. Usually under normal circumstances, operational creditors will not have any voting right during the corporate insolvency resolution process, and all the voting rights will be exercised only by the financial creditors. And if we also look at the definition of financial creditors, there is absolutely no differentiation between a secured financial creditor or an unsecured financial creditor. Simply when a debt is given against time value of money or against payment of interest, the same will be classified as a financial debt. Now, initiation of CIRP, how a corporate insolvency resolution process could be initiated, under what circumstances, and who could initiate. Section 6 defines it, where a CD commits a default. So the very first condition is there has to be a default, and before default there has to be a loan. So once there is a loan or liability to pay, the second condition is that there has to be a default. If there is a default towards the supplier in payment of his dues, or a default in repayment of interest or principal, so it is said to that a default is committed. Now, this definition of default is in variance from the definition under SURFACI Act. Under SURFACI Act, a bank can initiate action only when the loan account is classified as a non-performing asset. Whereas under IBC, the term non-performing asset, NPA, does not find any mention. It simply says where a default. So a default could be a default of only 1 day, whereas NPA could usually be declared after a continuous default of 90 days. So it is very important that we must understand under IBC, the provisions are very strict. So if there is a default by a corporate person in repayment of interest or principal even for 1 day, so it gets qualified to be admitted under the provisions of IBC. So it says where a CD commits a default, a FC, a financial creditor, an operational creditor, or the CD itself may initiate corporate insolvency resolution process in respect of such CD by way of filing an application before the AA, having territorial jurisdiction over the place where registered office of the corporate person is located. So application can be filed by the financial creditor, or by the operational creditor, or by the CD itself. All the three are given powers to initiate application for initiation of CIRP proceedings. The jurisdiction of the tribunal is defined. It is only where the registered office of the CD is located. So there is absolutely no ambiguity as far as the territorial jurisdiction of the adjudicating authority is concerned. The minimum amount of default must be rupees 1 crore. So the defaulted amount must be 1 crore or more. This amount was raised in March 2020 after the lockdown was announced by the Government of India. Prior to that, the minimum amount of default was only rupees 1 lakh. As a result of which, lot of cases under Section 9, which deals with filing of operational creditors, were filed. Instead of filing recovery proceedings, lot of creditors found it very attractive to file applications before NCLT for initiation of CIRP proceedings, because the repercussions are very drastic. The directors, the management immediately loses control of the company upon admission under CIRP. So this threshold limit has been increased to rupees 1 crore, and now the limit is 1 crore as it stands today.